15th Congress of the Republic of the Philippines, first regular session, introduced by Senator Manny Villar. Explanatory note. The Revised Penal Code, Republic Act 9208, and the Republic Act 9262 are the existing laws under which prostitution or addressed and trafficked women and children can seek recourse. The existence of such statutes, notwithstanding the Coalition Against Trafficking in Women Asia Pacific, CATW-AP, estimates that 300,000 women are prostituted or engaged in prostitution in the country, and another 75,000 children are forced into the trade. But the plight of victims of sexual servitude, the trade, is deplorable. In a transaction of 700 pesos for sexual services, 300 pesos goes to the pimps, while the women, if they are lucky, will get the rest of the cash. Most often, these pimps would sell these women for a much higher price and keep the money for themselves. The National Commission on the Role of Filipino Women in a study validated the same by citing that 2/3 or more of the income of women engaged in prostitution go to the pimps and owners of bars or establishments. The dastard acts involved in the trade, as well as the unpleasant experiences of women and children and even of men and the sexual servitude, as documented, leave painful sting and set society in imbalance. The legislation is submitted with the following objectives. 1. To give meaning and to honor the international instruments of which the Philippines is a signatory, particularly the Universal Declaration on Human Rights, Convention on the Elimination of All Forms of Discrimination Against Women, Convention on the Rights of the Child, Convention Against Transnational Organized Crime, including its protocol to prevent, suppress, and punish trafficking in persons, especially women and children, and other international human rights instruments. The measure declares its commitment to end the continuing sexual exploitation of women, men, and children, and all forms of gender-based violence by creating an enabling environment where the human rights of women and children are promoted, protected, and fulfilled. Number 2, it recognizes prostitution as a human rights violation that calls for coordination and sustained response from all agencies of government as well as non-governmental organizations that comprehensively addresses the factors that perpetuate sexual exploitation. 3, it recognizes that women and children are systematically victimized by and in the system of prostitution and must therefore be given protection and support by the state instead of being treated as offenders. Number 4, it recognizes that eliminating prostitution is essential for women and children to genuinely and meaningfully participate in nation building. And number 5, it recognizes that the law on vagrancy has outlived its usefulness and that vagrants should be looked upon not as a common criminals but as victims of their ill circumstance. With the introduction of this legislation, I am recommending the public discussion on important concerns, namely prostitution and vagrancy, and the appropriate carrying out of a public policy that would best protect our women and children. Early cognizance of this bill is earnestly sought. Signed, Manny Villar. An act promoting the administration of justice for women, children, and other oppressed sector, establishing for the purpose an omnibus framework to address the problem of prostitution, support services for its victims, higher penalties for perpetrators and promoters, and for other purposes, be it enacted by the Senate and House of Representatives of the Philippines and Congress assembled. Section 1, short title, this act shall be known as the Anti-Prostitution Act of 2010. Section 2, declaration of policies. It is hereby declared the policy of the Senate that 2.1. In accordance with the relevant international instruments, particularly the Universal Declaration of Human Rights, Convention on the Elimination of All Forms of Discrimination Against Women, Convention on the Rights of the Child, Convention Against Transnational Organized Crime, including its protocol to prevent, suppress, and punish trafficking in persons, especially women and children, and other international human rights instruments in which the Philippines is a party, declares its commitment to end the continuing sexual exploitation of women, men, and children, and all forms of gender-based violence by creating an enabling environment where the human rights of women and children are promoted, protected, and fulfilled. 2.2 recognizes prostitution as a human rights violation that calls for coordination and sustained response from all agencies of government as well as non-governmental organizations that comprehensively addresses the factors that perpetuate sexual exploitation. 2.3 recognizes that women and children are systematically victimized by and in the system of prostitution and must therefore be given protection and support by the state instead of being treated as offenders. 2.4 recognizes that eliminating prostitution is essential for women and children to genuinely and meaningfully participate in nation building, and 2.5 recognizes that the law on vagrancy has outlived its usefulness, and that vagrants should be looked upon not as a common criminals but as victims of their ill circumstance. Section 3, definition of terms. The following terms are defined for the purpose of this act. 3.1 Prostitution, any act, transaction, scheme, or design involving the use or exploitation of a person, whether through the performance of such act or mere demonstration thereof, whether woman, man, or child, for the sexual gratification of pleasure of another in exchange of money or checks, profit, or other consideration, or any act that promotes or facilitates the accomplishment of the said act, transaction, scheme, or design. 3.2 Person exploitation in prostitution refers to a woman, man, or child used, exploited, or employed for another person's sexual gratification or pleasure and for the monetary gain of profit of others. 3.3 Child refers to any person below 18 years of age, or one who is over 18 but is unable to fully take care of or protect himself or herself from abuse, neglect, cruelty, exploitation, or discrimination because of a physical or mental disability or condition. 3.4 Sexual exploitation refers to the practice by which women are sexually subjugated through abuse of violation, either overt or covert, of women's sexuality and physical or mental integrity as a means of achieving power and domination, including gratification, financial gain, and advancement. 3.5 Sexual act refers to sexual intercourse, including genital to genital, oral to genital, anal to genital, or oral to oral intercourse or contact, insertion of any instrument or object into the genital or anal orifice of any person, bestiality, masturbation, sadistic or masochistic abuse, exhibition of the genitals or public area of any person, and other acts of sexual nature, whether the same is made between persons of the same of opposite sex. 3.6 Establishment refers to any business or enterprise including but not limited to sauna, bath, massage parlor, discotheque, bar, restaurant, resort, lodging house, motel, hotel, theater, ship, vessel, cab or taxi, or any other vehicle, or any dwelling, house, jail, detention center, structure, or building serving as a cover or venue for prostitution, or any group, association, or organization that engages in prostitution activities. 3.7 Cult refers to, but not limited to, fanatic groups that entice, recruit, and condition any person to become sexual offerings in organizational rituals or in other circumstances as part of membership requirements. Section 4 Acts of Prostitution. The following acts constitute the crime of prostitution. A. Any person who gives or delivers money or any other consideration in exchange for the actual performance or mere demonstration of a sexual act by a person exploited in prostitution, regardless of whether the person giving or delivering money or any other consideration is the recipient of sexual act. B. Any person who is a recipient of a sexual act, whether such a recipient has given or delivered any money or any other consideration for the procurement of a person exploited in prostitution, provided, however, that for the purpose of this section, being a recipient shall include persons or crowds before whom a person exploited in prostitution has actually performed or merely demonstrated that sexual act. C. Any person who offers another for sexual exploitation in exchange for money or any other consideration. D. Any person who induces, persuades, entices, compels, kidnaps, recruits, or in any manner procures or causes a person to serve in an establishment knowing that the same is involved in prostitution activities, or when he or she has reasonable cause to believe that such establishment is involved in said activities. B. Letter E. Any person who organizes or arranges travel, tours, and or tourism-related activities that involve the sexual exploitation of any person or the escort services of any person who is expected to perform the sexual act as defined in this act. F. Any person who as a part of cult or religious obligation uses, entices, recruits, or offers any person a sexual offering or favor to other members of the cult or religious organization. G. Any person who uses information technology or any form of media for the purpose of prostitution. H. Any person who derives profit or advantage from any of the prohibited acts defined in this section as owner, operator, manager, head, director, officer, or agent of the establishment where the prostitution activity takes place or of the establishment serving as a cover or venue for such prostitution activity or aiding another establishment or person involved in any prostitution activity. I. Any person who leases, subleases, or in any manner allows the use of any dwelling, house, structure, building, land, or any other property knowing that the lessee, sub-lessee intends to use or uses it for prostitution activities as defined in this section for the purposes of this paragraph. The owner of the dwelling, house, structure, building, land, or any other property used for prostitution and his or her agent shall be presumed to have knowledge that the place is being used or intended to be used for prostitution unless he or she disproves it. J. Any member of the military or police establishment or any government official or employee or any person in authority who commits, causes, or promotes, facilitates, allows, or tolerates the commission of any of the acts defined in this section or who in any manner provides protection to the perpetrators of the said acts. K. Any official or employee of any jail or detention center or any person connected thereto who commits, causes, promotes, facilitates, allows, or tolerates the commission of any act of any of the acts defined in this section upon inmates or who in any manner provides protection to the perpetrators of the said act. For purposes of this section, it is understood that the prohibited acts of prostitution may be committed in any establishment as defined in Section 3F above or in any other place not otherwise mentioned in Section 3F. Furthermore, in attempt to commit any of the acts defined in this section is also prohibited. Section 5. Persons exploited in prostitution as victims. Any woman, man, or child, regardless of sexual orientation or gender and identity, used or employed for another person's sexual gratification, pleasure, or exploitation, and for the monetary gain or profit of others as defined in Section 4 of this Act, shall be treated as victims of prostitution. As such, they shall not incur any criminal liability under this Act, except those penalized under Section 6B of this Act. In addition, the consent of the person exploited in prostitution to the commission of any of the acts defined in Section 4 of this Act shall not in any way exempt the offender from or mitigate his or her criminal liability. Section 6. Penalties and sanctions. Letter A. Any person found guilty of the acts defined in Section 4 shall suffer the penalty of imprisonment of 20 years and a fine of not less than 1 million pesos, but not more than 2 million pesos. Letter B. Any person guilty of the acts defined in Section 4 who is also exploited in prostitution or had been exploited in prostitution shall suffer the penalty of imprisonment of 10 years for the first offense and 15 years for the succeeding violations and a fine of not less than 500,000 pesos but not more than 1 million pesos. Letter C. Any person guilty of attempting to commit any of the prohibited acts shall suffer the penalty of imprisonment of 15 years and a fine of not less than 500,000 pesos but not more than 1 million pesos. Letter D. When the offender is any establishment as defined in this Act, the penalty shall be imposed upon the owner and operator of manager, or the directors and officers, or the responsible officers or agents of the establishment, corporation, partnership, or association found to be engaged in any of the acts defined in Section 4 of this Act. In addition, the establishment, corporation, partnership, or association shall be immediately closed and its registration and or license to operate shall be revoked. A sign with the words "off limits" shall be conspicuously displayed outside the establishment by the Department of Social Welfare and Development for such period as the department may determine, which shall not be less than 1 year. The unauthorized removal of such sign shall be punished by imprisonment of 6 months. Letter E. When the offender is a foreigner, he or she shall be deported immediately after service of sentence and permanently barred from entry into the country. Letter F. Any person found guilty of committing or attempting to commit any of the prohibited acts under Section 4 shall, in addition to the penalties stated in this section, undergo counseling, rehabilitation, and mandatory education on the human rights situation of victims of prostitution with DSWD for a period of not less than 3 months, but no longer than 1 year with the DSWD. The DSWD shall submit to the court a report on the rehabilitation of the offender. Section 7. Civil liability for prostitution. Persons exploited in prostitution may file independent civil cases for damages against the persons natural or judicial responsible for their exploitation. Provinces, cities, and municipalities shall be liable for damages, in addition to any other criminal or administrative liability under existing laws. The persons exploited in prostitution, when it is proven that the responsible authorities had knowledge or were informed of the activities constituting prostitution but did not take proper action within a reasonable period of time. For purposes of this section, the responsible authorities shall be deemed to have knowledge of the prostitution activities when the same are common knowledge in the community. Section 8. Prosecution of cases. Any person who has personal knowledge of the commission of any offense under this act, or the person exploited in prostitution, the parent, spouse, siblings, children, or legal guardian, or the law enforcement agencies, or the task force created under this act may file a complaint for prostitution. Section 9. Immunity of government and DSWD accredited NGOs from undue interference. Members of the National Anti-Prostitution Council and the DSWD accredited non-governmental organizations that are involved in the implementation of anti-prostitution programs are granted immunity from suit and other legal proceeding in connection with the enforcement of said programs. Section 10. Venue. A criminal action arising from a violation of this act shall be filed where the offense was committed, or where any of its elements occurred, or where the person exploited in prostitution actually resides at the time of the commission of the offense, provided to the court where the criminal action is first filed shall acquire jurisdiction to the exclusion of other courts. Section 11. Prescriptive period. Cases under this act shall prescribe in 20 years. The prescriptive period shall commence to run from the day on which the person exploited in prostitution is delivered or released from the situation of exploitation, and shall be interrupted by the filing of the complaint or information, and shall commence to run again when such proceedings terminate without the accused being convicted or acquitted, or are unjustifiably stopped for any reason not imputable to the accused. Section 12. Exemption from filing fees. When the victim of prostitution institutes a separate civil action from the recovery of civil damages, he or she shall be exempt from the payment of filing fees. Section 13. Confiscation and forfeiture of the proceeds and instruments derived from prostitution. In addition to the penalty imposed for the violation of this act, the court shall order the confiscation or forfeiture in favor of the government of all the proceeds and properties derived from the commission of the crime, unless they are the property of a third person not liable for the unlawful act, provided, however, that all awards for damages shall be taken from the personal and separate properties of the offender, provided further that if such properties are insufficient, the balance shall be taken from the confiscated and forfeited properties. When the procedures, properties, and the instruments of the offense has been destroyed, diminished in value, or otherwise rendered worthless by any act or omission, directly or indirectly, of the offender, or it has been concealed, removed, converted, or transferred to prevent the same from being found, or to avoid forfeiture or confiscation, the offender shall be ordered to pay the amount equal to the value of the proceeds, property, or instruments of the offense. Section 14. Trust Fund. All fines imposed under this act and the proceeds and the properties forfeited and confiscated pursuant to Section 12 hereof shall accrue to a trust fund to be administered by the Council, to be used exclusively for programs that will prevent prostitution and protect, heal, and reintegrate prostituted persons, that will prevent prostitution and protect, heal, and reintegrate prostituted persons into the mainstream of society. Such programs shall include but not limited to those provided for under Section 20 of this Act. Section 15. Human rights of persons exploited in prostitution. Persons exploited in prostitution have human rights that must be respected, protected, and promoted by all branches, agencies, and instrumentalities of the government in law enforcement, drives, criminal prosecution, civil suits, service provision, and program development and implementation. These rights include but are not limited to: A. The right to be treated as human beings. B. The right to dignity and security of person. C. The right against any form of discrimination. D. The right to equal protection of the law. E. The right to be protected from abuse and exploitation. F. The right to seek redress for violations of their rights and to have their complaints appropriately addressed. G. The right to fair and human treatment. H. The right to sensitive and appropriate legal, health, economic assistance, and livelihood and other social services. I. The right to organize themselves and fight for their legitimate concerns. And J. The right to be consulted on any governmental initiative affecting them. The persons exploited in prostitution shall not be detained on by reason of a raid or in the name of law enforcement. There shall be at least one social worker or one representative from a non-governmental organization known to be working with women exploited in prostitution present during raids. During raids of establishment and at any stage of the investigation, prosecution, and trial of complaints for violation of this Act, law enforcers, prosecutors, and judges shall not disclose to the public the name, personal circumstances, and other information that will establish the identity of the person exploited in prostitution unless the latter consents thereto in writing. It shall also be the duty of law enforcers to ensure that persons exploited in prostitution are not exposed to the media on the occasion of a raid. Law enforcers who allow or facilitate the exposure to the media of persons exploited in prostitution shall suffer the penalty of 6 months imprisonment without prejudice to the filing of other criminal, civil, and administrative charges under applicable laws. Section 16, confidentiality. It shall be the responsibility of any journalist, reporter, editor, publisher, or producer of print and broadcast media to protect the identity and privacy of persons exploited in prostitution, most particularly on the occasion of raid or rescue operation. Any journalist, reporter, editor, publisher, or producer of print and broadcast media who exposes to the public the identity of any person exploited in prostitution without her or his consent thereto in writing or causes the publication of any picture or video that violates the dignity and other human rights of the person exploited in prostitution shall suffer the penalty of imprisonment of 6 years and a fine of not less than 500,000 pesos but not more than 1 million pesos. In addition, the owner or publisher of the print or broadcast media found guilty of the violation shall pay a fine of 500,000 pesos. This shall be without prejudice to the right of persons exploited in prostitution to file a civil action for damages for the violation of their human rights or for any injury caused them by the publication. Section 17, entrapment prohibition. Law enforcers shall not use entrapment as a method in law enforcement activities when the same will involve the sexual exploitation of persons as defined in Section 3B of this Act. A law enforcement officer who resorts to this method shall suffer the penalty of 8 years imprisonment. Section 18, requirements for hotels, motels, and lodging houses. Notwithstanding any legislation, ordinance, or rule to the contrary, every hotel, motel, or lodging area shall, letter A, maintain a reception and registration area for guests and patrons that is readily within the public view. B. Maintain open garages or those that do not have doors or any closing mechanism. And C. Maintain good lighting in all its entrances, exits, driveways, and garages. Garage. No hotel, motel, or lodging house shall be allowed to operate in any part of the Philippines without complying with the preceding requirements. For the purpose of this section, hotels, motels, and lodging houses already operating shall have 6 months from the effectivity of this Act to comply with this provision. The failure of any hotel, motel, and lodging house to comply with this section shall result in the cancellation of their license or permit to operate. Section 19, responsibilities of local government units in anti-prostitution efforts. Local government units shall exercise their powers to curb prostitution within their respective jurisdictions. It shall be unlawful for any local government unit to issue licenses or permits for the operation of any establishment that is used or intended to be used for any prostitution activity. Any such license or permit already issued prior to the effectivity of this Act shall be deemed automatically revoked or cancelled and shall not be renewed. Their responsibilities shall include conducting public information campaign against prostitution, carrying out rescue operations, and ensuring the safety or security of victims of prostitution. Local government units may employ elements of the National Bureau of Investigation (NBI) or the Philippine National Police as provided for under Republic Act Number 6975 as amended by the Republic Act Number 8551. The national government shall ensure that local government units conscientiously engage in anti-prostitution activities, provide support for the same, and intervene when necessary. Section 20, the National Anti-Prostitution Council. There shall be a National Anti-Prostitution Council composed of the Department of Social Welfare as the lead agency and shall have as members the following. Letter A, Department of Social Welfare and Development, DSWD as lead agency. B, National Commission on the Role of Filipino Women, NCRFW. C, Department of Labor and Employment, DOLE. D, Technical Education and Skills Development Authority, TESDA, National Economic Development Authority, NEDA, Department of Health, DOH, Department of Interior and Local Government, DILG, Department of Justice, DOJ, Department of Tourism, DOT, National Bureau of Investigation (NBI), Philippine National Police (PNP), 3 non-government organizations (NGOs) to be selected by NGOs providing support services to victims of prostitution, 3 representatives of or persons exploited in prostitution. The National Anti-Prostitution Council shall perform the following functions. I develop program addressing prostitution and the needs of persons exploited in prostitution and those vulnerable to be exploited in prostitution. The program shall include public information and education campaign against prostitution, crisis intervention service, education assistance, socio-economic assistance such as sustainable livelihood, skills training, and financial support for scale businesses, and integration and complete aftercare programs for persons exploited in prostitution, among others. 2. Identify, not identity, and if necessary, create centers in strategic places all over the Philippines that will provide health services including counseling and therapy, temporary shelter, and other crisis intervention services to persons exploited in prostitution. The rape crisis centers established under Republic Act No. 8505 and the hospital-based protection units for women and children may also serve as centers servicing persons exploited in prostitution. Number 3, ensure that units are created and identified within relevant government agencies, particularly those composing the council, that shall focus on addressing prostitution and the needs of persons exploited in prostitution. This shall include units within the National Prosecution Service offices on local government units that shall specifically focus on the prosecution of offenders under this act. Number 4, ensure that relevant government agencies work in close coordination with each other in addressing prostitution and the needs of persons exploited in prostitution. 5, develop and implement a training program for law enforcers, public prosecutors, judges, government lawyers, government healthcare providers, social workers, and barangay officials that aims to increase their understanding of prosecution as a system and equip them with the perspective and skills to appropriately address the needs of persons exploited in prostitution, respect, protect, and promote their human rights, and pursue the prosecution of offenders. 6, ensure that local counterparts of the council are created in every municipality, city, and province. 7, undertake and lead the prosecution of any violation of this act. 8, promulgate when necessary rules and regulations for the effective implementation and enforcement of this act. 9, continuously conduct surveillance and monitor establishments to prevent prostitution. They shall promptly investigate any establishment suspected to be engaged in prostitution and shall take appropriate measures in coordination with the local government unit concerned and other relevant government agencies for the speedy prosecution of the offenders, and then undertake corrective and enforcement measures to stop activities in tourism constituting, promoting, or facilitating prostitution in consultation with government agencies and non-governmental organizations working for the elimination of prostitution. Section 21, mandatory services to victims of prostitution. To ensure healing, recovery, rehabilitation, and reintegration into the mainstream of society, concerned government agencies, particularly the members of the council, shall make available the following services to trafficked persons: 21.1 counseling, 21.2 free legal services, which shall include information about the victim's rights, the procedures for filing complaints, claiming compensation, and other legal remedies to them. 21.3 emergency shelter or appropriate housing, 21.4 medical, doctor's assistance, or psychological services, 21.5 livelihood, employment, entrepreneurship, and skills training, which include financial assistance to be sourced from the available funds in the Department of Social Welfare and Development, or agricultural fund assistance from the Department of Agriculture, or small loans granted to government financial and lending institutions, including those provided by local government units. Section 22, appropriations. The amount necessary to carry out the provisions of this act is hereby authorized to be appropriated in the General Appropriations Act of the year following the enactment of this law and every year thereafter. All local government units are likewise mandated to allot not less than 5% of their gender and development GAD budget and not less than 5% of the local department fund of the local government units LGUs for programs, projects, and activities aimed to control prostitution activities within their jurisdiction, including the development and the conduct of deterrent information campaigns directed to potential and actual buyers of prostitution sex. In the next 7 years after the effectivity of this act, a fund shall be instituted that will address and help the victims of skills acquisition, training, livelihood programs, and a comprehensive program on self-reliance, entrepreneurship, and similar concerns. The same shall be funded from the following sources. Letter A, 1% of the total earnings made by such government agencies as Philippine Amusement and Gaming Corporation, BAGCOR, Duty Free Philippines, and Philippine Charity Sweepstakes Office, PCS of B. Savings generated from various tourism campaigns initiated by the Department of Tourism and Philippine Tourism Authority. Section 23. Implementing rules and regulations. The Council shall promulgate the necessary implementing rules and regulation within 60 days from the effectivity of this act. Section 24. Separability clause. If any provision of this act is declared invalid or unconstitutional, the remaining provisions not affected thereby shall continue in full force and effect. Section 25 Repealing Clause. Articles 202 and 341 of the Revised Penal Code are hereby repealed. All the other laws, decrees, ordinances, and rules inconsistent with the provisions of this Act are hereby modified or repealed accordingly. Section 26 Effectivity. This Act shall take effect upon completion of its publication in at least 2 national newspapers of general circulation.